thought that the procedures in this case went outside the normal procedures, and that very high-level senior government people made decisions on this case. Can you elaborate on this? I mean, first of all, who and which decisions, and why was that outside the normal procedure?
Well, I'd say you start with a real focus on the compression of time, the extraordinary schedule on which all of this happened, on which I think the cat hearing that occurred, at 7 o'clock in the evening on a Sunday is just a stunning example of
it. With notice to the attorneys Friday night after or Saturday.
A telephonic notice left on a message.
They were notified at Sunday at 4:20. They were notified at Sunday at 4:20. Surprised they didn't get the message till Monday, and the hearing started at 7. Do you think that's extraordinary?
Absolutely extraordinary.
Do you think it might be construed as designed to make sure that he didn't have counsel?
I'm quite certain that that's the case.
Before you go further, Mr. Irvin, would you concur with that judgment?
I would absolutely concur with that.
And if you were writing this report, would you make that a conclusion of this report, that there was a deliberate intent that he not have an attorney?
I would certainly draw that conclusion, and I would do it explicitly in the report.
Thank you, Mr. Skinner. Do you draw that conclusion? If not, why not?
I'm sorry, I'm not really clear on what the question is.
The question is, do you conclude from the fact that for that, what hearing was this? That for the protection hearing under CAT, which occurred at 9 o'clock on Sunday night, his attorneys were notified at 4:20, or at least the message was left on Sunday, 4:20 on Sunday, when they obviously thought that the odds were nobody's going to legal office at 4:20 on Sunday. The hearing occurs at 9. He had no legal representation. Would you conclude from that, and if you wouldn't, why wouldn't you, that there was an intent that he not have legal representation?
Let me say it certainly appears that way.
Well, what would mitigate that appearance?
The process that they were using in the Arar case was, I don't want to say exempt, what was different that you would use on an ordinarily.
Well, was it in a class that was sometimes used but not often, or was this unique?
The 235C process is not used often.
I understand.
The removal
235C is a very rare
That's correct.
situation. But even within 235C, was this done given the compression of time, given on a Sunday, given the other circumstances? Would you say that this is the way 235Cs are normally done?
No. And let me add that we questioned why this had to be moved so fast, moved so rapidly through the system. To be calling to set up an interview on a Sunday and to contact attorneys on a Sunday is highly questionable.
And to contact the attorneys on a Sunday for Sunday evening interview, and to go ahead with the interview when you didn't reach them.
That's correct.
And what response did you get to that?
The Arar was not entitled to an attorney.
He's not entitled to an attorney. So why did they call an attorney?
I'm going to be getting into some redacted portions of our report.
They called the attorney for secret reasons and for equally
not secret, but for other reasons, which would be attorney-client privilege.
Wait a minute, whose attorney-client privilege? Mr. Arar's privilege, his attorney's privilege?
No, those that made the decision to move forward without the attorney.
Why? Now, you say that Arar was not entitled to an attorney in this hearing. That is in the public report. Why isn't it?
That is not clear under the 235C proceedings, at least in my understanding, as to what his rights are.
So he may have been. Right. So he may have been entitled to an attorney.
We do know that he cannot, does not have a right to go to go through a hearing, does not have the right to appeal, and it's not clear as to what rights he has with regards to representation.
So it's not clear. But nonetheless, they went through the motions of affording him the right to counsel by calling the attorney on Sunday, but not the reality.
That's correct.
Now, why they did that is an attorney-client privilege? Why he was given the appearance but not the reality? How can that be attorney-client privilege? Whose attorney? Which attorney? What client?
It would, in this case here, it would be the decision. It's those individuals who made the decision to proceed without allowing representation for Arar or allowing an attorney to be present during the interview.
And some attorney would have advised that decision maker, and the advice he gave him would be attorney-client privilege.
Yes.
All right, never mind the advice he gave him. What about the decision that he made? What was the reason for that? That's not privileged.
And we say that. The reason he was, they wanted to do the interview, they wanted to remove as soon as possible, which is, we were never able to determine why. And when they said, if we do not have...
So for undetermined reasons of haste, he was denied effective assistance of counsel.
That's correct.
And you are still attempting to figure out why, what was the rush?
I don't know if we'll ever determine why, because those people that made those decisions refused to be interviewed.
Well, you can subpoena them?
They do not have subpoena authority.
Well, who are those people?
That
What are their
would
names?
be,
Maybe we'll
INS
subpoena them.
Maybe that's the INS commissioner, the chief of staff at INS, and that would be the chief counsel at INS.
At the time, obviously.
Yes.
Now, Mr. Horton, Professor Horton, I cut you off because you hadn't finished answering. You said that this was handled unusually, even for a 235C case. It was handled, and decisions were made by higher-ups who would not normally have been involved. Can you elaborate?
Well, I think it's quite clear here that the individuals who were involved were not just the commissioner and the commissioner's counsel, but also figures in the Department of Justice.
How do we know that?
I think it comes out from the report as who was involved in these meetings at which the decisions were made, and we note that there are two individuals from the office of the Deputy Attorney General who were involved, and we know that key decisions were made by the Deputy Attorney General then as acting Attorney General to enable the entire process to move forward. But, you know, to me, it seems highly unlikely that the professionals within the INS would have proceeded in this highly expeditious and expedited, contracted, compressed fashion. I think violating normal rules that they would follow involving bringing in counsel, amongst other things, and allowing reasonable notice without pressure coming from above for that to happen. I believe that's what happened here. And if we look at the redacted passages of the report, it's clear that immediately before this there's discussion in which we see a footnote which has not been redacted and which the key word appears, habeas corpus. So it's clear that there's been extensive discussion here about the fact that
There's been extensive discussion about how to avoid allowing him to exercise the right of habeas corpus.
bingo.
Mr. Skinner, do you concur with that? Do you think there was a deliberate, let's call it a deliberate scheme on the part of high government officials to arrange things in such a manner, expedited in other ways, so as to make his right to file a writ of habeas corpus not real?
Mr. Chairman, I'll be happy to answer that question in a closed environment.
I'm asking your opinion. You don't need a closed environment for an opinion.
Sir, I am representing the Inspector General's office. I'm not going to offer my personal opinions. I do have personal opinions, but I don't think that's...
All right, Mr. Irvin, as an experienced observer and a former Inspector General, do you think the facts and circumstances indicate a deliberate scheme to make sure that he couldn't exercise his habeas corpus right?
It seems to me that there is no reasonable conclusion otherwise that can be drawn from the facts and circumstances that we know.
Now, was there any proper legal motive for such a scheme?
I can think of none.
So you would conclude that such a scheme had to have an illegal or extra-legal motive?
Well, I don't doubt that the scheme, if we can use that word, was motivated by an intention to protect the United States.
That's not the question.
But
Let me just observe, because I want to comment also on the comments by Mr. Rohrabacher before. Lots of terrible things have been done in history by people who are well motivated to protect their country or other noble goals. The reason we have laws and due process is to protect people from men and women of zeal who may be perfectly well motivated. So that's not the question.
And I agree with that.
And
I was
if
not
somebody
trying to-
has the motive of protecting the United States, and in order to do that, does illegal things, we have laws because we don't trust people's even well-intentioned motives to protect us.